Okay, everyone, I think we are ready to begin. Welcome to this ArbitralWomen panel on the enforcement of arbitral awards. On behalf of ArbitralWomen, I would just like to say that we are very pleased to be a part of this Arbitration Week. It's very important, and we're honored that we could be part of this. And I think that we have a wonderful group of speakers for our panel today, with a lot of diverse experiences in the area of enforcement of awards, and a lot of it does involve the Caribbean. In the interest of time, I'm going to briefly introduce our speakers, but you have a short bio on your chair, hopefully, and there's a more extensive one, so you can always learn more about us later, and we'll just try to go straight to the substance.
Dana, do you want to say who you are first?
I am Dana MacGrath. I'm with Sidley Austin. I'm also a board member of ArbitralWomen and the moderator, so to speak, of this panel, organizer, moderator, and panelist. I'm wearing a lot of hats today. So. Natalie Reid is a partner at Debevoise in Plimpton, and she has a lot of international arbitration experience. She's a national of Jamaica. And prior to joining Debevoise, she was the Associate Legal Office in the International Criminal Tribunal for the former Yugoslavia. Angeline Welsh specializes in international arbitration and public law. She's with Matrix Chambers, and she's worked on a number of complex arbitrations and also sits as arbitrator. Angeline is admitted to the bars of England and Wales and also Belize. She's appeared before the Privy Council on leading public law and commercial cases from Belize and Turks and Caicos, and she has also acted on some of the significant constitutional and arbitration appeal cases from Belize to the Caribbean Court of Justice, the CCJ. Shan Greer is a Caribbean arbitrator, mediator, and lawyer. Her practice carries a strong emphasis on major construction and infrastructure projects. She is based in St. Lucia and represents clients throughout the Caribbean, as well as internationally in North America and Europe. She has many years of experience as a commercial litigator in cases involving construction, banking, insurance, intellectual property, energy, and employment. She is a fellow with the Chartered Institute of Arbitrators and has a master's degree in construction law and dispute resolution from King's College London. Yasmine Lahlou is a partner at Chaffetz Lindsey in New York. She has extensive experience in international arbitration and judicial proceedings relating to arbitration. She is trained in both civil and common law systems. Yasmine was previously at Clifford Chance in New York and Castaldi Moore and Partners in Paris. Yasmine is fluent in English, French, and Italian. So we will start with remarks from Natalie, and we will be sort of going in this order, save for an exchange between us.
Thanks very much, Dana. I assume that everybody can hear me. I am fully mic'd up, so I will try very hard not to yell. I have the privilege of leading off and in some ways sort of setting the table for the rest of the panel. For those of us who have been following or have been involved in the efforts to promote and advance international arbitration in the Caribbean, a lot is often said about the importance of being a party to the New York Convention. So I want to talk a little bit about why that treaty is important and contrast it with the other main treaty for international arbitration, which is the Washington Convention. So if we take a step back and think about why parties choose international arbitration, especially when compared to litigation, there are a number of things that people frequently cite, whether it is the confidentiality of the process or the prospect of avoiding the other side's courts. One of the things that has always featured on those lists, though, and has driven the remarkable success of international arbitration over the last several decades is the relative ease of enforceability of the resulting decision. the award. So instead of having a judgment of the courts of a particular jurisdiction, which you then have to take around to whichever other jurisdictions have assets and hope that that judgment will satisfy whatever the applicable requirements are in those other jurisdictions, what we have instead in international arbitration are a very clear, strong legal frameworks that are designed to promote ease of enforcement across the world. So what are the common features of both of these treaties? Well, let me take a step back and talk about what the treaties are. So the New York Convention, so-called, because it was executed in New York, is the Convention for the Recognition and Enforcement of Foreign Arbitral Awards. It is one of the most successful international treaties in the history of business. It has 157 state parties, and its application has been extended to a number of other territories, including the BVI. And it is viewed as being one of the key treaties for international commercial arbitration, which is frankly what we spend a lot of our time talking about. The Washington Convention, so-called because it was executed in Washington, is the convention that goes along with ICSID, or the International Center Settlement of Investment Disputes, which is an arm of the World Bank, for investment disputes. So those tend to be state to investor, state to corporate, or state to individual, more rarely, and provides a separate forum, definitely for avoiding the home courts of the state against which the investor would be bringing claims, for the resolution of those disputes, again through arbitration. So what are the common features of both of these treaties that explain why they're viewed as being sort of the twin pillars of the success of international arbitration from the perspective of enforceability? So I've touched on one already, widespread application. So the New York Convention is 157 states parties. The Washington Convention has 153 contracting states, and about 8 more have signed but not yet ratified. Those numbers, again, they sound very big, but what does that mean as a practical matter? If we threw up a map of the world and you colored in all of the countries that are these states parties, let's pick a color. It's ocean blue for what I see out of the window. Almost the entire globe would be ocean blue. So that is almost all of the surface of the globe, almost all of the population. And for those of us who have awards and need to enforce them, they include many and pretty much most of the jurisdictions where assets are going to be found. So that's the first key part. Second is one of the other main concerns that litigators face and that parties in litigation face is the uncertainty of being able to enforce your judgment. So the converse in international arbitration, if you're going towards certainty, 2 key things. The first is there is generally sort of a single jurisdiction or a single body that has the authority to annul your award. So you go through this entire process, you spend a fair bit of time and resources getting an arbitral award, and you end up with something that you would hopefully like to get enforced if you are the winning party. And in international commercial arbitration, under the New York Convention, it is only the courts of the seat of the arbitration, the legal home of the arbitration, that have the authority to annul that award. In the ICSID context under the Washington Convention, it is a completely sealed system. So the party that wishes to challenge that award does not go to a court. So this is, again, from the perspective of those who view arbitration as being an alternative to courts. The ICSID system is even that much more an alternative because it is sealed off from courts. If you want to annul that award, you apply to ICSID, they establish a committee. And it is that committee, also set up of arbitrators, that would review the award. The final point, sort of the common feature of both of these treaty regimes, is that there are very few grounds on which you can annul that award. So it is not about relitigation of the dispute. And again, actually, let me clarify that. So wherever you are, there's not supposed to be relitigation of the dispute. In the ICSID context, the grounds on which you can seek annulment are really focused on the integrity of the process and and the validity of the process. We'll see this again when we come to New York Convention enforcement. So when you have your award and you want to take it to one of these over 150 other jurisdictions, again, the grounds on which you can challenge, very narrow, focused on the validity of the process, the integrity of the process, and due process, for want of a better word. What are some of the key distinctions between the two systems? Again, I've already touched on them. And they are largely driven by the unique features of this kind of sealed regime that ICSID has. So there are even more limited roles for courts in ICSID cases. When you have the award that is the result of that completed process. So if you seek annulment and it's either rejected or granted, and the case is reheard, once that award comes out of the ICSID system and you take it to the courts in these member states, you cannot challenge that award. You cannot even challenge it on the limited grounds that you could challenge in the New York Convention. The question of whether or not it shall be recognized as a matter of treaty law, it must be recognized as if it were a judgment of a court in that state. Now, when it comes to enforcement, there will be separate questions about immunity or other defenses that may be available when it comes to enforcement against the assets. But the award itself will be recognized. Under the New York Convention, the courts of the seat still retain a preeminent role. So one of the things that you will hear us talk about a lot when we think about creating an arbitration-friendly jurisdiction, for example, that arbitral award, once you get the result, I've said it's only the courts of the seat that can annul it, it will be the domestic arbitration law of that seat. Now, an arbitration-friendly seat will have grounds that are similarly narrow to the grounds for recognition and enforcement that we see under the New York Convention. Arbitration-unfriendly seats, which thankfully the BVI is not, will essentially get closer and closer to relitigation of the dispute. The courts will second-guess the decisions of arbitrators. Sometimes they will intervene in the arbitral process itself. Now, while the New York Convention does limit the grounds on which you can challenge recognition and enforcement, lawyers are creative and parties are motivated. So you will frequently find that there's still room for divergent practices among different states when it comes to what some of the language in the New York Convention will either allow or will specifically require. So in particular, there's one that has spurred quite a lot of not just litigation but scholarly debate, and that's what some of my fellow panelists are going to talk about, the public policy exception. So I'll pause there.
I think yes. Now it's Angeline.
Well, thank you very much, Natalie, for that excellent introduction to the landscape, and particularly the New York Convention, which I'm going to talk a bit about, and this issue of to what extent should national courts and enforcement relitigate issues. It's clear that one of the backbone to the success of arbitration has been the New York Convention, and in particular this the concept in the New York Convention that there is a pro-enforcement bias and that the arbitral award should be final and should not be second-guessed. But one of the issues that I think does arise and pose some difficulties to many courts is the question of, well, if you've got a final award, but on enforcement the issue is raised that the underlying agreement which the award is concerned with is illegal, to what extent should the court look behind that final award, and what is the test which governs that? So what I want to do in my short remarks today, and there may be some further debate about this because I think Shan's going to make some observations from the Caribbean perspective and Dana from the US perspective on a case I'm going to talk about. What I want to do is do a bit of a deep dive on that particular issue of finality versus illegality from the perspective of the way the English courts have looked at it and the way the Caribbean Court of Justice has looked at it. Both courts which are very relevant to various jurisdictions in the Caribbean. So I want to start by just looking at English case law on this point, and in particular one Court of Appeal case of Westacre, which looked at an award dealing with a consultancy agreement in respect of the sale of military equipment to Kuwait. And the way in which that agreement was set up was that Westacre was to receive a substantial percentage of any contracts which were entered into by the Ministry of Defence of Kuwait. So things went awry, there was a dispute, and the dispute provided for ICC arbitration in Switzerland. So this was a case seated in Switzerland, and the Swiss courts had supervisory jurisdiction. The issue which was raised in the arbitration, one of the defence points in the arbitration, was that this contract really, in effect, was a bribery contract, because the amount of money which the Westacre was due to get in relation to these contracts just indicated that money was being paid on elsewhere. So in the arbitration, squarely raised was this issue of bribery. It was rejected by the tribunal. It then was defendants then sought to set it aside before the Swiss courts, who had the supervisory jurisdiction over the arbitration, and the Swiss courts set it aside. Then Westacre came to the English courts to seek to enforce the award. And the English court said, well, look, there are two principal issues that I've got to decide in this case. Firstly, is it open to defendants in the enforcement proceedings to challenge the arbitrator's finding on fact of the bribery issue? So that question of, can you relitigate in the first place? And if you can, if the party alleging bribery could successfully prove the bribery allegations to resist enforcement. So in relation to the first question, the majority of the Court of Appeal in Westacre said, well, look, it's really of crucial importance to see what the tribunal did here and what the Swiss court did when there was an application to set aside the award. And they said, well, look, there are four factors which are really relevant to that first issue as to whether we should litigate it or not. The first was there evidence before the tribunal that this was a straightforward commercial contract? There was. They also took into account the fact that arbitrators specifically found that the underlying contract was not legal. And then they said, well, let's look at the process of the tribunal. Well, there's nothing to suggest that the arbitrators were incompetent, and there's no reason to suspect collusion or any bad faith in obtaining the award. So they said, well, take into account the fact that the tribunal has looked specifically at this issue, assessed the evidence and determined that it's fine, and there's nothing to really, nothing suspect about the way in which the arbitral tribunal did that, then we're not going to look into it. So they stopped at the first issue. The minority, Waller, in that decision said that he wasn't content with dealing with it in that way. He said, well, actually, the way you've got to look at the first question is think about what is the nature of the illegality which is alleged. And if it's sufficiently serious, essentially you can go back and revisit the tribunal's determination. So he felt that actually when you're answering the first question, it wasn't good enough to just look to see whether there's something the tribunal had looked at. You needed to take into account the nature of the illegality. So that's the way in which the English courts, that's where they've got to in terms of their analysis. And of course it's a majority decision. So now I want to go to see, well, how was this particular issue tackled by the Caribbean Court of Justice? So in the case of BCB Holdings and the Belize Bank against the Attorney General, the court was asked to enforce against the government of Belize an award which considered which found a settlement agreement to be valid. The settlement agreement had been entered into the parties because they'd had a dispute and the BCB Holdings had a claim for some money against the government. And they said, okay, government said, well, look, I haven't got enough money, so the way in which we'll settle this is I will give you certain promises, certain warranties. And essentially there were tax concessions. It's slightly more complicated than that, but that's essentially what they were. And the tribunal looked at this. Government didn't take part in the underlying arbitration proceedings, but the tribunal, so far as it could tell, tried to address all of the issues that the government may have raised had it been there, and the issues which would have been raised, which the tribunal looked at, was that the way in which the tax concessions were set up was inconsistent with the taxation legislation in Belize. So they looked, well, hang on a minute, well, how do we deal with this? And the tribunal said, well, actually, what we're really looking at here, we're not pronouncing on the tax legislation of police, we're looking at contractual warranties which were given under the contract. They also looked at authority. There was a particular section under the taxation legislation which allowed the government to remit tax, and they said actually we can construe that broadly enough to find that the minister had the relevant power to enter into this contract. So the tribunal looked at this very issue of whether or not the agreement was consistent with the taxation legislation, and they found that it was valid and awarded damages against government police. So BCB Holdings then took it to police to enforce. Eventually it gets to the Caribbean Court of Justice. And the Caribbean Court of Justice was then confronted with the same issue that the Court of Appeal had in West Acre, which is, you know, to what extent should we look behind the decision of the arbitral tribunal? And the way in which CCJ approached it was the same way in which the minority had approached it in West Acre. And they specifically say that they agreed with the minority in West Acre. Said you have to really look at the nature of the illegality and the nature and seriousness of the alleged illegality and the extent to which it can be seen that the same was addressed by the arbitral tribunal. That was something that they would take into account. And they determined that they would not enforce the award. So they, having looked at, they said, well, look, our difficulty with this is that the potential nature of the illegality is very serious because it's inconsistent with the taxation legislation. Government cannot agree to do something inconsistent with the taxation legislation by itself. We suspect it needs legislative approval. So let's go into it. And they analysed the validity of the agreement in full detail, and they did it without actually the benefit of all the evidence that the tribunal would have had, but they went back and they reopened it and decided that they weren't going to enforce it. So the question, I think, therefore, is, you know, strictly speaking, has the Caribbean Court of Justice taken a different approach to the English courts? And I think on that point of the relevant tests that you would apply and the approach they applied, and certainly they have, because they went with the minority decision in West Acre. But I wonder whether, I'm hopeful, that this decision of the Caribbean Court of Justice actually will be an outlier in their jurisprudence on enforcement. And the reason that I say that is that I think what happened when the Caribbean Court of Justice looked at this agreement is because the provisions of the agreement looked like they were setting up a certain taxation regime, I think they thought, actually, look, this is pretty serious and this is not something that we feel that we condone. And so they felt that this is something that they needed to look into, and it would be wrong to say, well, we accept that this tribunal outside our jurisdiction has looked into it, and so we don't need to do it again. And one thing I was wondering is, there is another case. There's very few cases in the English courts where the English courts have refused to enforce an arbitral award, much like the US jurisdiction and others. Very few. But there is one case called Soleimani and Soleimani where they refused to enforce it, an agreement, an award, which was basically for smuggling carpets out of Iran. And that particular dispute was to be governed by Jewish law, by a Bethdin tribunal. The tribunal determined that that smuggling agreement was valid as a matter of Jewish law, so they upheld it and they said it's valid. But the English court said, well, look, we can see the tribunals looked at it, but on the face of the award itself, this is not something which would be lawful. It would be contrary to public policy of the UK courts to enforce it. And in a way, I think what the CCJ was trying to do, but you know, the sorts of the steps at which it took to do that were perhaps not quite right. But it was looking at the agreement, thinking, I feel that the agreement in the BCB Holdings case was a bit more akin to that, in that I feel that it's a matter of Belize public policy, which is obviously what it is looking at when it's seeking to enforce it. It was an agreement was a bit more, which was something which was really contrary to the fundamental norms of the way in which the executor is supposed to operate in the Caribbean. So that's sort of what I think about it. I'm sure we hear from Shan as well, but Dana, you acted on the US enforcement of that particular award. Do you want to say how the US court looked at it?
Sure, I'll speak briefly on this. I mean, I think one important point when you're looking at the public policy exception to enforcement, I think I've turned my mic off, or is this better?
Yep, it's on.
Okay. So when you're looking at the public policy exception to enforcement of an award under the New York Convention, the public policy that you are looking at is the public policy of the court or the nation in which the award is sought to be confirmed. So here we had an award that was rendered in London, had in fact been confirmed by the London courts, had not been confirmed by the CCJ after being fully litigated in the courts of Belize, and then was brought to the United States in the District of Columbia, which is where a lot of the cases to enforce awards against foreign sovereigns in the United States are brought for enforcement. And the district court, and then indeed the Court of Appeals for the DC Circuit, considered these issues, and both the district court and the DC Circuit confirmed the award. And they looked at the public policy issues slightly differently. I think in part because the arguments that were advanced on behalf of the government of Belize to resist enforcement in the United States may have been a little bit different than how they were described in the CCJ. But the public policy that was focused on by the government of Belize in seeking to resist enforcement of the award in the United States was the United States public policy against foreign corruption as embodied in the Foreign Corrupt Practices Act. And what Belize argued was that the court should refuse to enforce the award because it was, quote, the result of a corrupt bargain between the two companies and the former Belizean Prime Minister. Which sounds quite different from what Angeline just described. The court relied heavily, as many courts in DC do, on the Termo Rio case, which is a DC Circuit case from 2007, which is most often cited for the standard for non-enforcement of an award for public policy purposes. And Termo Rio makes clear that the public policy exception only applies in, quote, clear-cut cases and where, quote, enforcement would violate the forum state's most basic notions of morality and justice. And very few cases, if any, have been set aside. I don't know of one case that's been set aside on the public policy exception in the United States. There may be cases out that I've just never heard of them, and you hear over and over again how it's the narrowest exception of the exceptions in the U.S. court system. But the court also concluded, and this goes to the point of how deeply will a court look at the underlying facts? Will they relitigate the case? They did not do that. They did acknowledge what Belize had purported to put in as evidence, but they said that Belize has not shown that enforcement would violate the most basic U.S. notions of morality and justice, and they noted that the arbitral tribunal did not find any corruption. And I think that U.S. courts give a lot of deference to the findings of facts and conclusions of law by the arbitrators, which I think is, sort of echoes the New York Convention's instructions to courts in that regard. And finally, they noted that the U.S. court's understanding of what the Belize highest court did, which may be a little bit inaccurate, but what the DC Circuit said was that the Belize highest court refused to enforce the award not because the underlying agreement was tainted by corruption, but rather because the agreement violated Belize's separation of powers, which goes to some of the things you were talking about, the authority of the Prime Minister to...
To be clear, I mean, there was never any suggestion of corruption in the Belize proceedings. and there was no evidence of any corruption. The question was about whether or not a minister had authority to enter into an agreement which was inconsistent with the taxation legislation. So it's really a question of ministerial power.
So you see how the cases sort of evolve in different ways.
Yeah.
But the bottom line in the United States is that that award was confirmed and the confirmation was affirmed and the public policy ground is not accepted. So that's the U.S. chapter.
Yeah, obviously this is one of the first decision that the CCJ has given on enforcement, and for that reason it's very controversial. And I think for my part, I've struggled with this one as firstly an arbitration professional and secondly as a Caribbean citizen, because obviously as an arbitration professional you understand and appreciate how important it is for awards to be final. But as a Caribbean citizen, I also appreciate some of the challenges that we have in our community. And I think it may be slightly difficult for persons who don't live in or in more developed countries to understand the issues that we have surrounding corruption and mismanagement. And I can appreciate for the US, they say, well, look, if there isn't any corruption, you know, this is really a separation of powers issue. And I think what this goes to show is the reason why we have this public policy exception, which is to give different states control over issues that shock their own conscience, and also how when something can shock one state, it may not necessarily shock another. Now, in a Caribbean context, corruption is a real issue, and not just corruption, but mismanagement of government funds. And many small developing countries cannot afford to lose the precious funds that they have. So I don't know how many of you have been to Belize, but Belize is not a country that can afford to lose millions and millions of dollars. And this decision has had a substantial impact on that country. So I'm pretty sure if you ask the average Belizean, this is shocking their conscience, and they would not want it enforced. And I think that would probably be an attitude across the Caribbean. And certainly from my part, having come from St. Lucia, we have our own equivalent to this with the Greenberg decision. And our Prime Minister in that instance did something fairly similar in terms of entering into agreements without following the necessary provisions. And our Prime Minister has done it on 2 or 3 different occasions. And what you have is a sensitivity to a particular issue. So the breach of separation of powers may not shock the conscience of the United States, it may not shock the conscience of England, but certainly in the Caribbean, we're going to be a little more careful. And I think for my part, and I've had, as a matter of fact, the last time I had discussion was with Pat Cheltenham just a few days ago. We were arguing about it fairly heatedly at the training session we had over the weekend. And I think the concern you have is that if you say the decision is a good decision, then you're anti-arbitration. And I reconcile it like this. I say, look, the whole point of public policy is to give you that right to make that decision. And I think in a Caribbean context, it's a right decision. Now the concern, of course, is, well, what does this signal for the future? Does this mean that the Caribbean will not be an enforcement-friendly jurisdiction? And of course, with BVI setting up a center in Jamaica, we don't want that sort of reputation. And it is unfortunate that the first decision coming out of the CCJ has to be one where the award isn't enforced. But I don't think this spells a trend towards not enforcing New York conventions. As a matter of fact, throughout the Caribbean, you'll find that most of the cases, the courts take a very positive attitude towards enforcement. And of course, as a lawyer, I have to prove that. So I just want to quickly look at a few cases and show you the extent to which our courts have gone to enforce convention awards. And since we're in BVI, obviously the most logical place to start is BVI. And there was a Court of Appeal case of IPOC versus LV Finance. And that was 2 BVI national companies, BVI companies owned by Russian nationals, and dispute related to an options agreement. And in the arbitration, LV Finance sought declaratory awards saying that the contracts were illegal because of various conduct. And the tribunal awarded them gave them the declaratory award saying that the contracts were illegal. They then sought to enforce that in the BVI. And in challenging it, IPOC essentially had two grounds. First, they said, in determining under whether or not to refuse to enforce the award, the court didn't only have to look at the grounds in Article 5 of the Convention, but it also had to consider common law principles. And those common law principles, under those common law principles, a declaratory award could not be enforced. Both the Court of First Instance and the Court of Appeal said, well, we're not going to consider common law principles, we're just going to look at Article 5, and under that, the declaratory award could be enforced. The second argument was, because the tribunal determined that LV Finance had participated in the illegality, that you shouldn't enforce the award because it was contrary to public policy to allow someone to benefit from their own wrong. And the court determined, well, no, if they were trying to enforce the contract, we'd agree with you, but they're actually trying to avoid an illegal contract. So on that basis, they're not, in fact, benefiting from their wrong, and therefore we're going to enforce it. Now, I think that is a ground on which legitimately, if you really weren't enforcement friendly, you could have easily avoided enforcement, and they didn't. Another case I wanted to look at is one from Bermuda. It's the Hawaii versus Samporium, and essentially it was more of a technical point. And in the tribunal, the party had argued a principle of law, or a principle of law which they did not plead. And the other side said, well, look, you didn't plead that, and therefore you can't rely on it. The tribunal said, we're going to allow them to rely on it. We will give you an opportunity to cross-examine, to deal with an open statement, to deal with it in closing statements. They lost, and then they sought to challenge the award on the basis that they did not have a fair opportunity to be heard. And the court, Bermudan court, quickly dispensed with that. So even on a technical procedural issue, they were still very enforcement friendly. Now on the face of it, you may say, well, look, Bermuda and Bahamas are very sophisticated Caribbean countries, so the courts are more likely to enforce it there as opposed to the other islands which may not be as developed. But even as late as 2009 in Jamaica, the courts took a very enforcement-friendly approach to an award. And in this one, it was actually even more extreme than the other two. That's the case of Rose Hall versus, I forgot the name of it, Ritz-Carlton. And essentially, it was a hotel management contract. Rose Hall terminated Ritz-Carlton, and the matter was going to arbitration in Georgia. Rose Hall applied for an injunction seeking possession of the property, and Ritz-Carlton applied to stay the proceedings on the basis that it was arbitration. Now Rose Hall said, well, in fact, possession of land is not something that's arbitrable. So on a matter of public policy, you shouldn't enforce it. And that is a fairly logical and common argument, and the courts got around that by saying, if the possession of land had to do with third parties, then we would deal with it. But because the possession had to do specifically with only these two parties, it fell within the scope of the arbitration agreement, and therefore it would allow the tribunal to deal with that issue. The court even went one step further to confirm that once the arbitration tribunal had dealt with that matter, the court would enforce any award made by that tribunal. So I give these examples to say, yes, the decision is not the most ideal for a region trying to get into the international market. In the perfect world, it would be better if they could have enforced it, but when you put it in a Caribbean context, I don't think it's an unreasonable decision, and I don't think it's going to set the tone for future decisions on awards.
Thank you, Shan. Yasmine, I think you have some comments on other twists of U.S. enforcement procedures.
Yes. Good evening, everyone. Wow, that was a very passionate and presentation, so it's very hard to follow.
Oh dear.
And I hope you'll stay awake for my anticlimactic presentation about the peculiarities of U.S. law on enforcement of foreign arbitral awards. And these are requirements that are not common in most other jurisdictions, and which is why I'm discussing them. And they are interesting because if you get to the US, for example in New York, and you can have an award confirmed, you have an access to a huge panoply of tools of discovery and enforcement against the debtor. You can get discovery of where their assets are all over the world. There was even a case where, back in 2009, where a creditor was able to force a bank in New York to bring in assets from outside the United States to give them to the creditor. So those specific requirements, those like thresholds to get you to being able to enforce an award in the US are, I think, partly justified by what you get once you get access to the US courts. And just a caveat, these requirements are not new. They're pre-existed our new president. So I guess they're just pre-existing conditions. So I will try to briefly go through 4 topics. Subject matter jurisdiction, personal jurisdiction, forum non-convenience, and statute of limitations. These are all concepts you are all familiar with in your civil contract practice. It's just they're not commonly used in the context of enforcement of arbitral awards. So the subject matter jurisdiction, in the United States you have two sets of courts, federal courts and state courts. State courts are courts of general jurisdiction. In federal courts, they need to have a specific grant of jurisdiction. I will not spend too much time on that because basically under the Federal Arbitration Act, if you have an action to enforce a foreign arbitral award gives you access to federal courts. I'm only mentioning this tonight because if you are the debtor and the award creditor starts the action in state court, you have a right to remove the case to federal court up until the time the trial has occurred, which is very, very late. And you cannot waive this condition normally because it is a matter of jurisdiction of the court. So I'm mentioning this tonight because last week we had an awful decision issued by a state court in New York where the judge vacated an award issued by an ICC tribunal based on a fairly dubious, sketchy application of a doctrine of New York law to vacate an award. And I'm fairly confident that had the debtor removed the case, the creditor, sorry, removed the case to federal court, this would not have happened. The second point I would like to discuss is personal jurisdiction. In the United States, you cannot confirm a foreign award unless the court has personal jurisdiction over the parties. Of course, they will have personal jurisdiction over the petitioner because the petitioner will have consented by bringing the action. Then, against the debtor, you have various options. The first one is by consent. Effectively, if you have agreed to arbitrate in New York, for example, you will be deemed to have consented to the personal jurisdiction of the courts in New York. Otherwise, you will have to look into general jurisdiction, which will look at your broad contacts with the jurisdiction. And until recently, this was a pretty wide avenue to ascertain jurisdiction against foreign parties, except that there was the Daimler case by the United States Supreme Court in 2014, which dramatically curtailed the availability of general jurisdiction against foreign parties. And you can have general jurisdiction against parties only if effectively the individual has his domicile in the forum or the company is incorporated there. So then your basis to get personal jurisdiction against the debtor will be specific jurisdiction. You will look at the specific contacts between the debtor and the jurisdiction. And if the transaction had no underlying contacts with, for example, the New York forum, it may end up being very difficult for you to get access to the New York courts. And as I said again, many people try that to get access to the courts in New York, for example, because they want to have access to the discovery and execution tools. One last basis to get jurisdiction against a debtor is Quasiin Rem Jurisdiction. And you're basically trying to ascertain jurisdiction against the debtor to the extent of the assets that debtor has in the jurisdiction. And the authority of the court will be not against the person, the legal person of the debtor, but against the assets present in the jurisdiction. And in an interesting illustration of that, a Dutch bank had an award against the Czech party, which I think was issued somewhere near, probably in the Netherlands, and they came to enforce it because that party had an account with Citibank in New York, and it was a $23 million award. But since there were 5 cents in the account, the court confirmed the award for the 5 cents.
Oh, no.
That's. I'm not sure which law firm litigated that. I want names.
Don't out them.
What is interesting on that is that under the New York civil procedure system, if you start an arbitration either in the US or outside the United States, there is a tool which enables you to freeze assets of the debtor that are present in New York for the pendency of the arbitration if rejecting that petition would make the award fruitless, I think is the expression, something like that. And so if you can identify those assets in New York, you freeze them, and then once you have your award, you can come back based on the Quasiin Rem Jurisdiction and then collect on your award. So if you're ever able to collect to identify any assets, especially in New York, you can get some form of security.
This the 7502C?
710102C, yeah. Exactly.
Rendered ineffectual.
Ineffectual, exactly.
That's a little shout out for the New York lawyers in the room.
Then, what is the other funny thing from the United States? Forum non-convenience.
My favorite topic.
So there's a lot of common law lawyers here. So you know what forum non-convenience is the court choosing not to exercise the jurisdiction that it otherwise has because it thinks that the litigation should be better handled elsewhere. So I will not get into the details of that doctrine because you know what it is. It is just that I think the United States may be one of the very few, if not the only, common law jurisdiction to apply that doctrine in the context of enforcement of foreign arbitral awards. And thanks to OGMID and thanks to GAR, we hear a lot about those very few outliers where that doctrine was in fact applied, whereas I do think that these very few situations where it was in fact applied, it was necessary because I think that the award creditor was trying to abuse the process. One of them, which is the Société Monégasque, this party had an award that it had obtained maybe in Russia. And they came to enforce it in the United States, but the purpose of their enforcement action was to go after an alter ego who had not been a party to the arbitration. And under the old personal jurisdiction law, pre-Daimler that I just mentioned, New York court had personal jurisdiction against that party, so it could not dismiss it on that basis, and it had subject matter jurisdiction. But the problem is that that party was primarily a Ukrainian party, and all the evidence and all the underlying documents were in the Ukraine. All the witnesses were in the Ukraine. So it would have required a court that has no connection whatsoever with the underlying alter ego dispute to expend extensive resources to effectively address what I consider a purely domestic Ukrainian dispute. So unfortunately, you have to be aware as litigants that this doctrine exists, that it's been applied, that it has raised a lot of controversy, but that if you look closer at the cases, these have been applied in extremely exceptional circumstances where I think as a matter of the specific facts at issue, the court's decision was justified. And I'll end my presentation very quickly with the point of statute of limitations against a concept that you're familiar with, but in most countries there is no limitation on the time you have to enforce an award in a jurisdiction. I don't know about you, but in the United States, to enforce a foreign award, you have 3 years, and from the time the award is made. What is interesting, however, is that the Second Circuit, which is the circuit the Federal Circuit for New York has decided that if you're past that 3-year time limitation, if you have a foreign judgment that has enforced the award, you can use and go around the 3-year limitation and use the foreign judgment to enforce it. And in New York, you have 20 years to enforce a foreign judgment, unlike the 3 years. That theory was tested also recently in the DC Circuit, and the lower court, the trial court, said you cannot do that. You cannot use a foreign judgment to avoid the time bar, the 3-year time bar. They basically said the Federal Arbitration Act preempts the availability of enforcing a foreign judgment. But the DC Circuit went with the Second Circuit and said, no, there's no preemption. The Congress, when it enacted the FAA, wanted to allow the greatest latitude to enforce foreign awards. So if you're past the 3 years, then go with the foreign judgment rule and the best for you. So that's an interesting thing. Stay tuned, because other circuits may choose another solution. This solution has been criticized because some think that it encourages forum shopping. I'm not sure why, since you go somewhere to collect on something, and you've been through already an extensive, probably costly arbitration. So I'm not sure I'm convinced by that forum shopping argument. But so this was my presentation about the quirky aspect of enforcement law in the United States.
One small quirk on the statute of limitations, or the limitations period for enforcing an award in the United States under the Federal Arbitration Act. So that's, I think, Section 207 that provides the 3-year time limitation. The concept of tolling a time limitation is a common law concept that's well accepted in the United States judicial system. And we did have a case in which we sought to enforce an award that was more than 3 years old, and we made the argument that the statute of limitations period should be tolled, and it was a unique set of facts, but the court did find that a large chunk of the period between when the award was made and when the conduct that basically impeded our client's ability to enforce its rights ended, that period was tolled and did not count it against the 3 years. So if you have an award that is more than 3 years old, you do face a limitations period, but it's not something that you should just dismiss without considering if there's an argument for tolling that limitations period.
It's like the TV series Better Call Dana.
Is there a reason for that 3-year period? Is there a rationale for having 3 years? Or is it just a thing?
I don't know what the rationale is. I don't know, maybe, I'm sure there is. I mean, I think most limitations period have some sort of legislative intent behind them, but I don't know what it is. So mindful of our time and that we have only until 6 o'clock, I'd hoped to open this up to questions, but I don't think we can do that right now. But I would encourage you to reach out to all of our panelists over the course of the next couple days, and we can keep this discussion going. And I'm also happy to answer any questions as the week unfolds about ArbitralWomen. And again, thank our panelists. I think this is a great panel. I learned a lot from each of you. So thank you.
Thank you.